Hey everybody, Scott Golightly, estate planning attorney here in Richmond's West End. Just had a meeting with a client who recently lost her father, and he had a will that named the daughter as the executor of the estate. So now she came to me to figure out, okay, what next? What do we do? And this was a pretty unfortunate situation. I mean, not only is she dealing with the grief of having lost her father, but her father's debts, lawful debts and liens on things like motor vehicles and deeds of trust or, liens on real estate exceeded the value of what he had in his estate. So I think in most states, but certainly here in Virginia, that means he's got what's called an insolvent estate. And insolvent estates are tough because there's just not enough assets to pay the creditors of the estate, and certainly not enough assets to pay the beneficiaries. And when somebody qualifies as an executor of an estate like this, they have to be very, very careful, because if they do use any of the estate assets to pay a creditor or pay a credit card bill, and it turns out that that estate didn't have enough money to pay other creditors who may have been a higher priority than the person or the credit card that the executor paid, the executor could be personally responsible to reimburse the estate and the creditors for those things. So if you're called to be an administrator or an executor in an estate, get some advice before you do anything, particularly pay any creditors, because it could come back to haunt you. That just makes a tough situation worse. So just wanted to share that with everybody, and wish you all, sorry again for the downer advice, but I hope everybody does have a good holiday weekend this weekend.